Again, this whole discussion is about how you allow those innovators to have a greenhouse so they can build their innovation and build their product and license it. And then that time is up and it goes to the public.
Hello, I'm Bruce Berman, host of Understanding IP Matters, the acclaimed series that provides leading innovators and experts the space to share their IP story, the good, the bad, and the incredible. Laura Peter is one of the most influential women in intellectual property. As Deputy Director of the U.S. Patent and Trademark Office, she was Chief Advisor to Andrei Iancu, one of the USPTO's most effective leaders. She is currently Executive Director of Research at the University of North Carolina in Charlotte, overseeing innovation transactions and partnerships. In her role, she supports corporate research and technology commercialization and encourages university-wide programs for IP awareness, development, and engagement with business. Laura received a BS in Industrial Engineering from Cornell University and a master's in Public Policy from the University of Chicago. She also holds a JD from Santa Clara University School of Law and a Master's of Law in International Business from King's College, University of London. Welcome, Laura. It's good to see you today.
It's great to see you. Thank you so much for inviting me to be with you today.
We're going to have some interesting information and some fun, too. When you were at the USPTO, your role was effectively Chief Operating Officer. That's a big organization. It was a time of great change and innovation and the agency. You managed much of the day-to-day as well as helped to shape policy and led the USPTO to a more inventor-friendly direction. What did you learn from that experience?
The agency is one of the most important in the U.S. government for advancing innovation in the nation. And we were very, very focused and proud to have that responsibility and really support innovators in a way that hadn't been done for a while anyway. We were concentrated on, at least from the operational side, on making things more efficient, starting to bring in AI tools to help with prior art searches and trademark searches and all of these kinds of things. So from an operational point of view, it was cutting edge and exciting. And then, of course, on the policy side, we were starting to consider new policies around artificial intelligence and some of the new technologies. And that was very exciting, too.
Over the past year or so, you've been developing a strong innovation culture at UNC Charlotte, making IP rights more broadly intelligible and conveying them as potential business tools. What goes into changing the culture at a university?
A huge amount of energy. What can I tell you? Universities are kind of like the old guild system. There are colleges that have their own direction and their own interest. And I find a lot of my time going out communicating to researchers, telling them what intellectual property is. There's a lot of confusion that intellectual property equals patents.
Right.
And I've had to have this, argument really with a number of researchers saying, no, intellectual property is much broader than that. And you have the ability to assetize and commercialize your intellectual property in a number of different vehicles. Patents are just one of them. So it's a lot of energy going out to educate. It's also building community around intellectual property, trying to bring thought leaders to the university. And then it's also engaging industry to say, here's what's going on at the university. Did you know? And I actually had a chief IP officer of a very large bank in Charlotte. There are a number of those. Say to me, Laura, I never knew this kind of technology was going on here. So we have we have a heavy lift to get the word out.
Right. What are some of the misconceptions about patents that you hear from researchers in general? Well, first of all, IP is more than patents, obviously, but do they think patents are like anti-competitive or anti-innovation, or what do you see or hear as they're thinking?
Well, for researchers in the university, they are incentivized to publish. Okay, so that is their primary goal in order to get tenure, is they have to rack up those publications. And so I've had a number of conversations with leaders of colleges. Some are more receptive, some are less receptive for obvious reasons as to how to make patents, commensurate or at least have a strong weight with respect to publications. In my view, getting a patent is more important than in a publication because you're actually assetizing something and it takes a lot longer than just getting a publication done. But, I respect their process and we just keep on having that discussion. So the first thing is that.
But you can file a provisional and still do the publication, right?
You can't. There's another misconception that's kind of floating out there. It's a little bit less these days because the culture is changing, I'm happy to say. And that is that knowledge should be open. Knowledge should be open source. We shouldn't lock it away. And so what I tell researchers is, first of all, you're getting your name associated with your innovation forever. It's on a patent. It's around the world. It will be respected by anyone. And by the way, you can also choose to not license it and give it to the public.
That's right.
So in the university context, there are some restrictions on that. Specifically, the university owns stuff that researchers do.
Work for hire. Mm-hmm.
It's a work for hire, exactly. And we have many of those discussions as well. So the ability to get a patent is not just to assetize or make money off of it. You still can donate it to the public, but your name will be associated with that innovation forever.
And of course, as you know, Laura, I mean, a patent, a lot of people forget, non-lawyers, patents publish after 18 months, whether they issue or not. So it's all there for people to see, just like the COVID vaccine patents. It wasn't being hidden. Those were published. The trade secrets that surround the building of the factory and the delivery of the system, making it efficacy high, that's different. But the patent is published.
Well, exactly. And so, I'm very grounded in what our founding fathers understood about philosophy. And this is so important, that a patent gives you the right to exclude others for a limited time, and then your invention is donated to the public after the 20 years. And the idea is that the knowledge is donated so that future generations can build off of that knowledge. And so you're not going to reach back, prior to 20 years and try to exclude anyone from your innovation. It's really about moving innovation into the future.
The system really works very well. It's no accident. I agree with you about the history of it's in the Constitution. We've all heard that.
Yes.
The right to have rights and to further the arts and sciences. But in the U.S., our entertainment industries, music, film, literature are phenomenal. It's not just a result of bright, aggressive people. And the same thing with science. I mean, we have a lot of really terrific folks, but the system has helped them. It's not perfect. It was never easy to enforce patents, even in the best of circumstances, but you can do that in the U.S. In most countries, you still can't, not effectively,
Exactly. And it gives you the right to be able to commercialize it if you wish. And I think the whole history of copyright, so I studied in London under one of the world copyright experts, a brilliant man named Dr. Sterling. And he wrote the book on world copyright law. So the history of copyright is slightly different because it had more of a tone of protecting the creators and the creators' work in a way that was less commercial than invention. And so I've watched some of these new cases coming down. McConaughey starting to trademark, snippets of his speech and stuff like that. And I think it's very interesting, that crossover of trademark and copyright and protection of likeness, which was identified as IP, but was a separate right before. So, and patents don't reach that at all.
I think people are starting to realize that there is, while certainly content and expression of creative expression is different from invention, there is that the notion of originality and ownership is still similar in that regard, and that now AI has sort of catalyzed the notion of copyright and who owns the copyright. We all do actually have copyrights, as you know. And how is it used and how can it be used? I think those are good issues in that they're making average people even aware of what content is and who owns it.
You're right. I hadn't thought of that
Yeah.
way. I mean, the whole idea of intellectual property being understood by more people in our community
Yeah.
is important. I always cite to, whatever ad is out there saying that our product is patent pending, that's actually great for IP.
Right. Right. It doesn't always mean very much, but it's
Yeah.
good.
Yeah.
And it's funny, copyright is more complex than people think, how people get paid and the different types of copyright, used in a film one way, used for performance. Copyright holders, at least say in the music business, they do get paid. They don't always get paid fairly, but they get paid. In the patent world, that's less the rule.
Well, and part of it is how the system is adapting to the different market forces. And, of course, we're going through an evolution right now at the USPTO with really strong innovator rules being put in place. And it's such a blessing so that those folks that are in the smaller companies, in their garages making inventions, have a chance to build out their portfolio. And you know what? IP is expensive.
Yes.
There's no way to get around it. Just the patent process itself
Right.
is expensive. And then the enforcement is a whole nother
That's
layer.
right. Right.
And so for the smaller inventors, the new administration at the USPTO is really working wonders.
Roger Smith and 1970s, I believe he was the director, commissioner of patents, undersecretary of commerce. And he said it's the sport of kings. I worked with him.
You lucky you.
Yeah.
No, and it is. And historically, folks in the IP world are considered a little bit more considerate to each other. I think that is devolving a little bit, and I have concerns about the geniality in our profession. But at least it's better.
Yeah, I just did a episode prior to this one, recorded with Phil Hartstein, who works in litigation funding, and he said the idea of doing a business deal on a patent or license, it still exists, but much less so. There's not those congenial, okay, let's cross license. I'll take a license. It's going to cost me X. Okay, that's fair. It's just sue me. It's going to take a long time and you're not going to get anywhere. So go ahead and sue me.
And I, as a big company, will outspend you.
Right, right. And that's really counter innovation, forgetting what it does to business and to individuals, but it's bad for the DNA of innovation. If a handful of companies get to determine what is truly innovative because they can afford to litigate, it's...
I will say there are varying degrees of innovation. There are some that are really revolutionary and cutting edge. Then there are some innovators who think they're revolutionary and cutting edge, but they're really not.
Right, right.
And then there are really, evolutionary additions.
Right.
So
right.
sifting those out is a project as well. And I was number 2 at a publicly traded company called A10 Networks.
Oh.
And we had what I would call visitations from various assorted patent asserters. And some of them were super serious. And some of them were like, we don't even do what you're talking about. So go, why are you going to sue us? So there is a balance that needs to be had here. But in general, being more pro innovation for those smaller inventors, I think is hugely helpful.
Yeah, the word, I was on a conversation with an inventors group, a webinar, and the compulsory licensing is still a dirty word among patent holders. But in some ways, some level of guaranteed royalty when there's an infringement or alleged infringement is not such a bad thing, I think. I think it can lead in the right direction. Will parties be disrupted and unhappy as a result of that? Yeah, both sides probably will be. Some will say I shouldn't have to pay, and the others will say we should get paid more.
I think that is a business solution, but it doesn't go back to the principle that I have a patent that is a property right, and I have the right to exclude others from my property. Now, I, as the inventor, may think I have a much bigger innovation than I do. I may have a much bigger piece of property than I do. And so I am passionate and I assert that in a way that may not be realistic. But I will tell you, I'm not for compulsory licensing. I don't think that's appropriate. I think getting the innovator to understand that their innovation isn't as broad as they thought it was is the more appropriate course.
Laura, in a recent Forbes article about conveying patent value, you said there's a need for IP storytelling.
Yes.
For creating a meaningful narrative. Building a story around an invention or dispute is what I've been doing at Brody Berman, my day job, since 1988. We're like the narrative people, and we've worked with litigants, law firms, defendants, plaintiffs, and even NPEs. Providing meaningful context creates value. What is an example of IP storytelling in your mind?
So there are a number of vehicles that I think are good storytelling vehicles. I already talked to you about ads that say, and our product is patent pending. I think that that's important. Another very important vehicle is, of course, getting narratives out into the media. And we did some work with the Bayh-Dole Coalition, and we had one of UNC Charlotte's success stories go up on the Hill and was awarded an award. And the company name was Aquasense. And the research came out of the lab in the university and actually went into the marketplace.
And yeah, it's something that I am immersed in. And, it's not as simple as it looks. You can't take out an ad in the Wall Street Journal and say, we have great IP, it's worth a lot of money. Even bright people, investors, don't really get it. IP doesn't appear, for the most part, on the balance sheet. It's goodwill. So it even further complicates matters. So how do we know something is worth what the patent holder or rights holder says it is? It's very, very difficult.
That gets into all valuation, and that's a whole complicated thing in and of itself. But I do want to go back to this storytelling idea. There is one other vehicle that I have been advocating for and promoting, and that is actually making part of the patent a vehicle for the story as well. Perhaps not the story of the inventor, but at least putting the patent in some kind of plain language so people know what it is and the kinds of things that the invention can be applied to. So that could be in the abstract that is, has less legal weight. Or it can be in some of the background, perhaps, of the specification. It's certainly not in the claims. But this idea that you give some context for the invention, and it's not just a very technical solution, but that's one way to convey how a patent has a little more value. So when it gets in front of a jury, they say, oh, yeah, I actually understand that part.
SEC went through this, I guess, in the 60s with documents like 13Ds, IPO offerings, and they were extremely complex, very legalistic. And now, you can actually read them. They're not exciting reading, but a person with a little bit of experience can understand what's going on, what's being said. And I think that's very healthy. It's helped the public, issuance of public stock.
It does help, and I will say this too, for folks that are creating patents or filing patents rather for the purposes of assetization and then trying to get funding off of that from venture capitalists, having patents that are somewhat readable is also super helpful because it's going to inform the potential investor on what the market is and how valuable those patents are as well.
In the Forbes article, Laura, you had mentioned you held an event at UNC in Charlotte.
Yes.
And it was reported as a win for everyone. And I'll quote, by recognizing the people behind the patents and placing their work in the public spotlight, the event invited deeper collaboration with industry and affirmed IP as a living, public-facing asset. It was also effective in raising awareness. One attendee confessed that they had no idea this kind of research was taking place at the university.
The importance of bringing together potential industry partners with the university researchers can't be underestimated. They don't cross-pollinate very well. Their worlds are a little bit separate. And there are some companies that know how to engage with universities and many who are gun shy. And working with a university is not always the easiest thing to do. So I appreciate that. So this was an effort to say, We've got a wonderful intellectual property innovation community in and around the University of North Carolina at Charlotte, where I am currently. And let's try and just raise everyone's awareness and celebrate innovation in a larger way, and also, frankly, in a fun way. We had the gala, which was sort of almost an Academy Awards style kind of thing. And people were like, wow, I want to go to that because
I want
that
to be on
was
the red carpet.
exactly. I had a green carpet.
How important is humanizing IP rights, especially in the AI age? Because I think the process is very mystical to people. This light bulb thing, this flash of invention, it's somewhat misleading. Yeah, there are flashes of, I just thought maybe we could do this. But developing an invention or any creative work is work. It's not just something that someone pulls out of the air and says, this is good, I'm going to patent it. What about the process? And what about AI too, which is, it kind of dilutes what the process is. No one's really quite sure what role AI played.
Two different questions, I think. I think of Thomas Edison's quote, that he had hundreds of test inventions and to see what the final product was going to be, or something along that line.
10,000 mistakes, he said, I made or something, but I was that much closer to a solution.
Well, and it wasn't that it was a mistaken invention. It was that it was a path on the process to getting to the invention. And what I try to convey to industry is what research in university is very different than research in industry. Research in universities takes tens and tens of years. You think of CRISPR, that started back in the 80s and really still only coming to fruition now. I mean, it's taken all that time. And the university environment allows that special greenhouse where professors can go into their lab for all of those years and build and discover, and then it can be applied, right? So there's a difference between the innovation that's going on in a research lab for that long period of time, and then that short spurt of research to get it to the applied end. So there's a lot of education around that as well. As far as AI goes, we are in the midst of the biggest evolution and revolution in technology of our times. This is the next industrial revolution. And it's so exciting and it's so important. And if we don't get on the train's going to leave without us. So I think protecting artificial intelligence tools is super important, and innovations that come out of artificial intelligence with the inspiration of humans always. That's what our law currently says. That is essential for us to be able to protect these innovations so we can build on them and keep the train going.
Mm-hmm. Now, we don't want to overregulate with regard, like Europe has been pretty deliberate in its regulation with regard to AI, but at the same time, and we want to compete worldwide, U.S., but at the same time, there needs to be some guide rails, I think, with regard to AI. What's your thinking about that?
So I think as far as having some national guardrails, that may be interesting for Congress to look at. I will say that the technology is so new right now and it's still evolving. I think it's very hard for us to know what to guardrail around. I was super excited that the state-by-state initiative seemed to have lost steam and may not be moving forward, because for a small innovator to have to comply with regulations in this state versus that state versus the other state would just stultify their ability to innovate.
Right. We don't know what we have to regulate. I think Andrea said that it's hard to regulate if you don't know what we're regulating.
Well, and again, AI is a tool. So if we think about it as computer code was in the 1980s, 1960s, 70s, 80s, that was viewed as revolutionary as well, and it certainly was.
But code was patentable. I don't think it is really anymore on maybe certain circumstances, but it was patentable for a while. But AI, is not going to be patentable. It's been...
Well, the results of AI in and of itself may not be. right? And we'll continue to have the discussion on whether and how AI tools should be protected. But you're right, the code has become a tool now, and that everybody uses, and you're like, well, of course. And what I see in the university is every single discipline is using AI to accelerate data analysis, to project out possible results, and so on and so forth. It does not take away from the original innovation. But what we saw in the patent office, I think, was it was close to 50% of all innovations coming into the patent office had some element of AI in them. I think that's a recent number. So, I mean, that just shows you its power to accelerate innovation that's really going to help humanity across many, many disciplines.
Laura, you have an engineering degree from Cornell. Now, there are more Cornell engineering grads who work or have worked in IP than can be counted. We were going to do a conference up there. I could not believe the number of engineering grads who were involved. Manny Schechter from IBM, Bill LaFontaine from IBM, Tiffany Norwood, who's on our boards, an entrepreneur, Talal Shamoun, Intertrust, Erwin Jacobs, Qualcomm. It just goes on and on. I don't know. What's going on at Cornell?
I was in the engineering school, of course, and I will tell you, it was super hard. I was like, all my friends were out having a good time, and I'm like, oh my word. So I think that it was two things. One is, of course, the discipline that engineering school instills is huge, but it's also that it's very cross-disciplinary. There are many other schools, and you're all stuck up in Ithaca. There's not many places you can go outside of Ithaca that are close by, so that, kind of pressure pot of everybody together, in my view, may have been one of the pieces that helped inspire us.
Because engineers often are kind of dubious about patents sometimes, but not at Cornell. It's very interesting. When did you become interested in IP rights, Laura? Was it a catalyst or event that, kind of said, well, this is interesting?
So my dad was vice president of Hughes Aircraft Company during the 70s and 80s, and he ran their patent and licensing program. So I kind of grew up with it. I grew up around it, and he was doing the first litigation in Japan, and managing the licensing and building a big portfolio. So yeah, I grew up in it. I never dreamed that I was going to be in it until I was in the University of Chicago, and I was actually studying defense policy. And I was kind of looking around saying, I've got technology, I have, policy interest, where can that apply? And my mom said, why don't you go to law school? Oh, okay.
Yeah. It's funny. I once had meetings with Bruce Rauner, who became governor of Illinois, and he was very knowledgeable about, he had a private equity company. He was very knowledgeable about IP. And I said, how did you get so, smart about IP? He said, well, my dad was chief patent counsel at Motorola. And we used to talk about patents at the dinner table.
Yeah, we did. So I grew up with it. I think that makes a big difference. It was always part of my culture. And so when I talk to these researchers and they've never engaged with patent attorneys or don't really know anything about it because maybe they're in a discipline that doesn't lend itself as well, it's having to train them from the very bottom all the way up.
Yeah. Well, it's a culture, the IP system, as it were, how things get licensed, how things get bought and sold, who are buyers, who are sellers, that is sort of a lot of patent attorneys initially are not exposed to that. They're about prosecuting patents, filing them, maybe litigating, but the culture and business of IP rights is somewhat different. It's interesting. I have a friend in the music business. He's a producer and he owned a studio, and he's extremely knowledgeable about copyright, much more so even than a lot of the lawyers I talk to, how they're actually used in practice and how they're I would say litigated, but when there's a dispute, people get made whole, quietly. Unlike in the patent world where if there's a dispute, everybody, it's war, it's nuclear war.
Well, there's a lot of money, right? So you have businesses at stake. And we talked about bet the company litigation often when it came to patents. If you get an injunction on a company's main product line, well, the company's toast. So, yeah, it carries a heavy weight, to be sure.
Since the American Invents Act, and there have been other issues in courts and legislative developments, the patents become less certain. What can we do to correct that? I mean, there are bills now in Congress, but what are some of the things in your mind? First, do patents need to be made more certain? And if so, how do we get there?
Yeah. So, I mean, I think the first thing, and I will say the USPTO current administration is making great strides in this direction to say, look, you get to choose your forum. If you want to invalidate a patent, you can go to the courts, you can go to the ITC, you can go to the USPTO, but you can't go to all three. And so that was this concept that we talked about a little bit earlier, that the litigation can become so expensive that a normal person can't even afford to engage in it. So this idea that you choose your forum, I think, is huge. The other thing that I think is really, really important towards certainty and reliability are some of the acts out there that are being proposed. The Restore Act, for example, puts in that's the one that puts in the injunction presumption.
Right. That's going to be tough to get through.
It will be very, very tough to get through, but I think having that discussion is helpful because it's making Congresspeople and the community aware. The Prevail Act is to codify a lot of what's going on in the USPTO now, this idea that you get one forum. So I think that would be wonderful if that could get through. And then, of course, PARA is the patent eligibility subject matter correction, if you will, saying, look, the courts have been kind of whittling away at what kinds of things can be patentable. But if we go back to founding principles in our Constitution, many more things were supposed to be patentable than what are currently deemed patentable now in our courts. So probably, in my view, the most important one out there is going to be PARA, because that will allow things like medical diagnostics, certain biotechnologies, artificial intelligence to be more solidified in a broader scope. Those kind of innovations that are so critical to the next steps in solving the grand challenges of our day, to have those protected, I think, is huge for the American system.
IP awareness is important to you, as you've stated, and innovation. How do you define awareness? How much awareness is necessary, and for whom? That's a question that we battle with at CIPU, and the feeling, at least our feeling, I don't want to influence your response, is that it has to start pretty young, because it's one thing to educate inventors or future inventors about the system and how you need to use it and understand it and its nuances and difficulties, but if the public and policymakers and others are disdainful of patents. They think patents kill because they're billboards that are taken out in Geneva and Washington, and it's going to be hard to make progress. At least that's my thinking. But what's your thinking?
One of my most delightful moments as deputy director of the USPTO was going to Camp Invention, and I had a 4-year-old lecture me on the difference between a patent and a trademark. And I was like,
I love that, yeah.
Now, that's maybe in a special world, but having young people see the value of innovation and that it's not something that, just big companies do and turn out and, we can march in and take rights and so on and so forth. The time and the effort and the creativity, frankly, the special mindset that goes into creating an innovation should be celebrated. So I go back to those ads again. I'm sorry to lecture again, but the ads that say patent pending, I think that that's important for the community at large to hear over and over again that this is something cool and valuable. So it kind of starts there.
Right, to know what it means and what it doesn't mean. It's 100% The way it was explained to me at Kenyon and Kenyon years ago when I worked, I'm not a lawyer, but I worked for lawyers who taught me like lawyers. And they said, it's like a mining claim. If you stake it out too broadly, it's hard to defend. If it's too narrow, it's yours, but it doesn't have much meaning. So it's 100% of whatever that is. That's yours. That's your entity. But giving it meaning or the context to put it in that gives it meaning and value, that's a whole other issue. And 99% or 98% of patents are thought to be or said to be have no value.
Well, and that's just wrong. And I've heard that before. And we talked about this a little bit earlier as well. The idea that patents are not only for just licensing, which is hugely important, they're a business asset, but they also help in marketing your product. How many people go out to VCs and say, we have 10 patents? That's huge. Communicating the value of what your products are, getting your name associated with your innovation, all of those things are super important. And it goes in varying degrees on how you educate, Congress and young people, and of course, serious researchers who are actually producing these innovations. So it's gauging your audience is always the trick, right?
Yeah. I have found that investors are pretty smart. When they're motivated. I think software makers have tried to get investors to be more hands-on about patents and patent analysis. And they'd rather hire someone to do that than do it themselves. But they recognize the value of understanding the white space, the industry, how strong are the patents? Are they litigation quality patents, or they just they get that more and more. And I think that's really healthy because they put it in a context that has meaning.
It is healthy. And the idea that patents are taking away technology from the community or withholding it, I think is wrong. Because again, this whole discussion is about how you allow those innovators to have a greenhouse so they can build their innovation and build their product and license it for a period of time. And then that time is up and it goes to the public. So I think that hasn't been emphasized enough, that we're about, building we built the giant, and the small person stands on the shoulders of the giant. That's what the principle is.
Yeah, it's published, and in being published, it's interesting that it gives competitors the opportunity to supersede that, to say, oh, now I see what's being done, or it's been codified. Now I can do something better, or I can take a license for this patent and then build on that.
Correct.
And for the inventor, you might say, well, it's unfortunate it has to publish, but because then I'm revealing stuff, maybe I shouldn't publish. But at the same time, it gives you a stake in the ground and ability to defend that.
Exactly. And that's what I talked to, again, the researchers about, is get your provisional. Let's get your provisional on file, so you have your stake in the ground as to what you're innovating. And it doesn't have to be perfect, right? Before you file the patent, you have to have a clear idea of what the innovation is and articulate that clearly. But you don't have to have the, absolute perfect end result in the invention done. And researchers are perfectionists. That's what I'm trying to convey.
We're getting towards the end of our time, Laura. A couple of more questions. Interest in patents appears to be waning. Businesses engaged in software, the internet, e-commerce, even AI are relying less on patents and more on other types of IP rights. This may be because of the certainty or uncertainty issue, but trade secrets are becoming more of a accepted strategy or in the mix. Is this trend likely to continue, and is it counterproductive for innovation, in your opinion?
So I think for so long as some of the areas of protection that we've talked about are not solidified, for so long as there's uncertainty as to the strength of the patent system in America, what people are going to drift towards trade secrets. If I can keep that isolated and nobody else knows about it, maybe I can keep my market advantage. So that would go to patent eligibility. I think subject matter eligibility is huge in that area. How do you protect AI? that's a huge issue. And I think these bills that are pending help to ameliorate some of that. There's also this idea that technology is changing so fast, we don't know which way it's going.
Mm-hmm.
So I might as well keep it secret for a little while. And then when I can when I can see where it's going a little better, then I'll file a patent. So there may be some of that mentality going on as well. And I do get that. You don't want to give your competitive secret sauce away, especially if it's not very well enforceable and you don't have the rights to figure out what the other side is doing, or you don't have the ability to figure out what the other side is doing in order to determine if there's infringement. In other words, if the AI patent, for example, is not very enforceable because you can't tell, that's another reason to keep things more trade secret.
Laura, what two thoughts would you like to leave with Understanding IP Matters listeners today? If they remember a couple of things from here, what should they retain?
The most important thing, I think, is that we are at the beginning of an amazing revolution in technology with artificial intelligence, biotechnology, engineering. I mean, the future is so bright, and I'm so optimistic for the future of technology and for innovation. And if we don't continue to protect their intellectual property in these innovations, we're going to fall behind as a nation. And I don't think that's going to happen. I think that people are talking about the right issues and grappling with the right issues, and that's elevating innovation and intellectual property. So I will continue to speak and hopefully contribute to that conversation.
Yeah, that's an important one. Great. Well, thank you for your time today. This was really enlightening. And I know you can't join us on April 23rd in Columbus because you have an event of your own in Charlotte. But yeah, as I've mentioned before on this on similar episodes, that the IP Awareness Summit will be held at the Center for Science and Industry in Columbus on April 23rd. But you'll be there in spirit.
Well, I'm disappointed I can't attend, but that is our invention of the year. And we've been planning this for the last year. So we would put it on that exact date.
I'll check with you next year. I'm going to check with you.
Awesome.
Thank you again. It's been a pleasure and an enlightenment and pleasure. And we'll have to do this again.
Delight to speak with you. Thank you for inviting me.
Hello, I'm Bruce Berman, the host of Understanding IP Matters, the critically acclaimed series that provides leading innovators and experts the space to share their IP story, the good, the bad, and the incredible. Understanding IP Matters is brought to you by the nonprofit Center for Intellectual Property Understanding, with the generous support of its partners and sponsors. Subscribe on the platform of your choice or email us at explore@understandingip.org. Content provided is for informational purposes only and does not represent the views of CIPU or its affiliates. This episode was produced for CIPU by Podsonic. Thank you for listening.